Chapter 26. The Trial. After months of ceaseless chatter and miles of newsprint, the so-called facts of the case had been annealed into the region's collective consciousness, immutable, irrefutable, and unassailable. Memory played tricks on the unwitting, and no one could remember a time when Wheeler was not guilty or when the papers had carried news of anything else. Like the populace they so faithfully served, the local news agencies were forever changed by the Kempton murder, transformed from simple purveyors of bland rhetoric into powerful arbiters of social opinion. They had also become the self-appointed guardians of the historical record. That the media were failing miserably on both counts mattered little. The damage was done, but the evidence of it was readily concealed, to be revealed only through the archaeology of time and distance. And so it was that in the first weeks of June in the year 1896, the much heralded yet widely perceived as unnecessary trial of Peter Wheeler hobbled toward the finish line. Wheeler was transferred to the jail in Kentville under the cover of darkness and with little accompanying hue and cry. His jail cell in Kentville became as much a watering hole for reporters as its doppelganger in Digby. The temporary change of scenery had little effect on the prisoner, one cell being as good as any other. The original Kentville jail and courthouse were built adjacent to the railway tracks on Cornwallis Street in 1828. A fire gutted the structure in 1849, and the center of Kentville's legal world was hastily relocated to two wooden structures just south of the old site, one building serving as the courthouse, the other as the jail in which Wheeler now found himself. In the decade that followed the Wheeler debacle, Kentville would build itself a towering courthouse, a beautiful brick temple of jurisprudence in the heart of the town. For now, however, the trial of the century was relegated to the drafty wooden barns by the tracks, serviceable if somewhat underwhelming. For all the media hype, the trial of Peter Wheeler began with a whimper. Despite Wallace Purdy and his highly touted examination of February last, it still fell to Justice Townsend and the prosecutor to impanel a grand jury to do what had yet to be done, issue a formal indictment of Peter Wheeler. On June 9, the jury, duly sworn and seated, heard the same evidence from the same 24 jury, duly sworn and seated, heard the same evidence from the same 24 witnesses who had testified at both Lovett's inquest and Purdy's exam. Witness followed witness, nose to tail, as the hearing never strayed from its well-worn path. For many of the witnesses, particularly Bernard Parker, who had now testified no fewer than 5 times including recalls to the stand, their statements had become rote. While the case as a whole remained the biggest story in the Maritimes, the seemingly endless slog toward justice had tarnished much of its initial luster. As for the press, having already printed each witness's testimony on at least one prior occasion, they gave this particular exercise in jurisprudence a very wide berth. The Bridgetown Monitor, one of the few tabloids to report on the grand jury, allotted the proceedings a scant 2 column inches, buried in the back pages alongside recipes and advertisements touting cures for ladies' nervous disorders. The only paper to carry news of the resulting indictment was the one it was printed on. With Peter Wheeler finally and formally charged with the murder of Annie Kempton, the legal treading of water came to an end. His day of reckoning was scheduled for June 26, 1896. To accommodate the anticipated crowds of curious onlookers, Townsend ordered a belated start of 10 a.m. A list of potential trial jurors was prepared, and in due course, the 12 men who would decide Wheeler's fate were chosen without much difficulty, only a few on the panel being challenged. David Noth was named as foreman, a task that normally carried a fair amount of record-keeping. Fortunately for Noth, Judge Townsend had imported from Halifax his favored court clerk, W.B. Wallace, to document the proceedings, and Noth's duties were sharply curtailed and largely ceremonial. As the appointed hour approached on the overcast morning of June 26, Townsend's crowd predictions proved spot on. The gallery was filled beyond capacity, leaving hundreds on the doorstep craning to catch a glimpse of the accused. Teams had labored since dawn transporting spectators from across the province. Horse-drawn carriages strained through the rain-soaked ruts, only to discharge their irate cargo in front of an already filled courthouse. Even witnesses and key players had to fight their way to the door and plead their case for admission. Bailiffs struggled to discern the legitimate from the fraudulent as hucksters tried every trick in the book to gain entry to the day's spectacle. A significant portion of the courthouse gallery was reserved for the gentlemen of the press corps, a special concession that caused no end of grumbling among the unwashed masses left languishing on the roadway. That reporters could come and go at their leisure, secure in the knowledge that their premium seating awaited their eventual return, did not sit well with the hordes relegated to the great outdoors. All major news agencies were on hand, represented by stringers whose accounts found their way into every paper in their syndicate. Some were even poached and plagiarized by those journals that could not afford to send a correspondent. As the clock struck 10, The parties assembled. Barristers Harrington, Viskfire, and Kopp appeared for the Crown. Wheeler's interests were represented, as always, by Mr. Henry Dwight Ruggles, with an able assist from a local lawyer named T.R. Robertson. Peter Wheeler was escorted into the court by the Harris brothers who were, in turn, flanked by an excessive number of constables from the Kentville area. Despite his shackles, Wheeler appeared poised, calm, and even a little hopeful. Following some preliminary comments from the bench, Mr. H. Viskfire rose and approached the jury. Viskfire was a master orator with a commanding courtroom presence. He could lull jurors and spectators alike with his dulcet tones, only to send them reeling as he thundered home some particularly salient point. His opening remarks for the prosecution, clocking in at just over an hour, seemed to flit by in the blink of an eye, so entranced were those in his congregation. Viskfire opened on familiar territory. He summarized the well-ingrained testimony from the inquest, Purdy's examination, and the grand jury hearing. The prosecutor was an alchemist, deftly transforming the intangible into ineluctable facts in a conjurer's trick that mesmerized as surely as it deceived. He then claimed that he did not wish to dwell on testimony widely perceived as old hat and made a promise, swearing an oath before those assembled, that the Crown had new and compelling evidence that would, once and for all, prove beyond any shadow of a doubt that Peter Wheeler had murdered Annie Kempton. Without tipping his hand, Viskfire alluded to the bountiful physical evidence, the subject of so many of Detective Power's press interviews. The prosecutor would say only that, after months of endless baiting, the forensic clues would finally be revealed. On that tantalizing note, Viskfire took his seat and called Mr. Stanley Rice to the stand. In spite of Viskfire's troth, those seeking this new and irrefutable evidence were in for a very long wait. The trial proceeded much along the same lines as all the prior hearings. The same witnesses rose and regurgitated the same testimony as before. The press, comfortable in their secured courtroom perch, refrained from revisiting each witness's statement, summarizing each repeat performance with a benign disclaimer. Nothing specifically new was elicited. Until the new material was released, the press pack had no interest in dancing to the classics. Instead, they dedicated their front-page columns to tiresome harangues on Wheeler's every sigh and twitch. Although body language analysis would not come into vogue for almost a century, it did not stop the assembled press corps from laying claim to proficiency in the nascent art. The prisoner manifested a great deal of attention as Mr. Viskfire referred to the new evidence to be produced. Subsequently, as the evidence of Mr. Rice was given, he seemed quite unconcerned. Like his friends in the media, it seems Wheeler was only interested in fresh meat. As the vigil for new evidence extended into its second day, the press amused themselves with a ceaseless dissection of the defense team's approach. Few doubted that Ruggles possessed the legal acumen to mount a proactive defense, yet he opted for a strictly reactionary strategy, a ploy that outraged Canada's national voice, the Globe. Ruggles's cautionary gambit was not well received. On cross-examination, he seemed surprisingly passive, often squandering his opportunity by simply having the witness clarify some inconsequential point. It may have been overcompensation to the presiding justice, who admonished Ruggles to rein in his normally pugnacious approach to the law. Reports from the first day of trial painted the defense as ineffectual and outmatched. Vanquished by the media, Ruggles withdrew to lick his wounds and ponder the alternatives. It was, in the end, all for naught. The trial's opening days held no surprises and few highlights, save for those manufactured by a listless press gaggle. All eyes few highlights, save for those manufactured by a listless press gaggle. All eyes were fixed to the horizon, desperate for their first glimpse of the trial's apogee, the appearance of Detective Nick Power.